Welcome to the Divorce Allies Circle on this lovely holiday weekend or week or day or whatever it is. We unfortunately did not take a day off because we know you guys are planning in the dark, and that is the focus of today's conversation, is kind of drawing a link between why we're collecting these documents, how it plays into not only the financial disclosures, which is the beginning part of this process, but also how it funnels into figuring out if you can keep the house, figuring out what your settlement offer is going to be. And at the very beginning, I think that people traditionally pull together various documents and don't really know what the implication is. So we do have Emily Flowers here today, which is our mortgage planning specialist. And we have a special guest, Adrian, who is our resident former lawyer, CPA more often than not, and kind of my right-hand person and partner in doing the settlement offers and the business valuations and all of this fun stuff in between. So feel free to ask your questions. She does have a background and understands, the filing process and some of the ins and outs that I think people struggle with or ask their questions to their attorneys, and then their attorneys charge them for all this. So these strategy sessions every week are for you to ask questions, gain knowledge, and really kind of put some of it into play. So if we can share resources and things like that of what are involved. Obviously, if you're in this group and you're part of the Divorce Allies, you understand that every week we send out an email that gives you the prior week's recording, some additional videos that we've created in the background that haven't quite been released. You would have received recently the Anchor, the Deal in Action. Adrian, Emily, and I actually shot a multi-part series about Plan in the Dark, and we're putting together a guide that will be in tandem with it. But this week you'll receive the first portion of it that will go back through what we talk about today. So if we get distracted with questions, don't worry. We have a full recorded series of it about exactly what you need to do to kind of plan in the dark. And even if you have already filed, even if you are already in the process, what we're going to talk about is why do these documents matter for considering whether you should be keeping the house or getting rid of the house, right? Or offering to sell the house. And it really plays in, the financial disclosures play into the settlement offer. So at all times, this is like eventually going to have multi-purposes. But Emily, maybe you can introduce yourself, maybe tell us what you've been seeing in the divorce world, and we can kind of round robin it a little bit until we get some questions, and then we'll go kind of straight into the financial disclosures. If you are in a state that you have not gone through the process of hiring a lawyer or working, producing this financial disclosure process or affidavits, enter your state in the comments and I'll pull up the forms and we can kind of take a look at the forms. We can see what your state requires, and Adrian's conversation can kind of be around, why are they asking for that documentation? Like, what is that information? How do we get it? So, Emily, welcome. How are you?
I'm great. How are you? It's Monday. It's a holiday, I think. I know it is for a lot of people because I'm getting a lot of text messages asking me questions today because they're off and I'm not. So, but yeah, this week or in the last week, I've met a lot of very interesting women doing very interesting things that will possibly become, they go into our repertoire of resources for us. So I found that very interesting that there's women providing, like, we think of the most creative services and the most creative way of doing things. I mean, I think everybody thinks like the men are the problem solvers of the world, but we really are. Like, we're like, I'm tired of repeating myself. So I'm going to do, I'm going to create a business around this. Um, I, the other thing that I'm seeing, like if we want to talk on the mortgage front, is we're still in that psychologically, I have to keep the house. I have to stay in this house. My kids have to be in this house. The neighborhood, the schools, what they're used to, all of those things. That is the emotional, psychological side of the house. And then there is the financial and the side of the house, which is what I'm responsible for. And that doesn't always align with the emotional side of the house. So sometimes the people don't even the one people that want to keep the house don't even like the house. They it's falling apart. There's deferred maintenance. It needs a new roof. I replaced my hot water heater and 4 toilets right at the beginning of the year because I woke up to water everywhere. It was not the most fun thing I've ever done, and it was really expensive. There's all of these things that we don't really think about when we're thinking about the house, and then we don't negotiate those things in. So a year or two ago, I think Melissa and I had this conversation, and it was a huge aha moment for us where we were like, wait a second, they should get an inspection. Anytime you want to keep the house, they should probably get some sort of inspection to just really go through and see plan for that within the financial in the house. And so it just that I really want to encourage you to maybe spend the money on an inspector, or maybe have somebody in your life who's a contractor that can do you a favor or something, and go through and really look at what this house is going to cost you to keep, because it may not be the best decision for you. Melissa, what do you think?
Yeah, I think a lot of today we're going to talk about, how you can pre-plan. So an inspection is ideal, understanding your credit score, pulling your social security statement, getting your tax returns. All of these things are going to be, even if you don't know what to do with the data yet, going to your bank and getting all of the transactions downloaded, 18 months of information is going to help you in the future, even if you don't know what to do with it. The goal of today is to sort of say, okay, here are how these pieces are going to come into play, and how you will need them, or if you have a forensic in the future, or if you have a business valuation in the future, is your business a Schedule C on your tax return? And you're like, well, I don't know. But if you have your tax return, when you work with somebody, they can kind of help you. And that kind of introduces how, Adrian's involved. Adrian's a CPA and a former lawyer who, as on the lawyer side, realized she really enjoyed the numbers more, which I think is kind of rare, because most lawyers and judges that we see really don't understand the numbers. But maybe, Adrian, introduce yourself and give a little background of what your experience is in the divorce world.
All right. So I, as Melissa said, I was a CPA before I became an attorney. So my practice focused primarily on large, complex divorces, which is how I met Melissa as an expert witness during my time. I have not been a divorce attorney in 10 years. I was only licensed in Missouri and Illinois. So even in those states, the law has changed dramatically since I was practicing. So I can't offer any legal advice. I wouldn't offer any legal advice, as I'm not representing anyone as an inactive attorney. But my background was in complicated divorces, pretty much any kind of asset, any kind of messy, sticky situation. My focus was never on custody, but I'm fairly well informed on all of the nuts and bolts of that. But high conflict custody is far from my expertise or interest, and it is its own beast. So my practice was very focused on the money stuff, all of the financial disclosures, all of the tracings, tax return analysis, business valuations, preparing deposition and testimony questions for my experts, for my coworkers, and to figure out what questions we needed to ask and unearth the right information to go forward. I only had 2 cases that did not settle in my time as an attorney that went to trial, and they settled. One of them settled before we finished trial. So my focus has always been on settlement. Most attorneys are going to focus on settling your case. The limitations are that attorneys have to have a certain level of understanding about your case in order to do so on your behalf. So they have a lot more information they've got to gather in order to do their due diligence as a professional. And so that's why sometimes when we're going to talk about what you need and what you can prepare and what your lawyer is going to, do and need from you, if you're not informed, your lawyer is going to have to go get all of the information to inform you. And that's what starts to get costly. So we're talking about the limiting that and what you have to go to your attorney for, because they're experts. They know what your court's going to do. They know where to find the proper filing documents, which we'll talk about. They know the propensities of judges. They know whether that county, city, or state is likely to grant spousal support, maintenance, or alimony. Those are all the same thing. I will use them interchangeably. They're going to know about child support. There are usually calculators for states, but sometimes there's a credit for custody. In Missouri, there is. Well, even a 50-50 custody arrangement, rarely when I was practicing, did you give a 50% credit to the payor spouse? So there are just these very nuanced things in the practice of law that vary by state, that vary by court. They can even vary by how judges treat different cases. So that's where your lawyer is really important. The more information that you can accumulate and prepare and organize for your lawyer, it's going to set you off on the best foot forward and managing those costs, because that all of those initial filings take a lot of time for lawyers, their paralegals, and their assistants to pull together. So we are talking about getting you all of that information in a format that your lawyer can jump in and get running for you.
Sent out this past week to the members, and we know that we have other people online or live streaming on YouTube. And we sent out to the members a Power Moves and Divorce. And so it's a download that we've put together. A lot of this is just understanding what the landscape is going to be as we progress forward, because the legal environment has very specific rubrics, right? And they want you to go down this very specific pattern. And so if you go in and you start interviewing lawyers because you think that that's the first step, right? And you haven't done any of this other stuff because you're like, I'm in the dark about the money. I haven't paid the bills. I don't have access to anything. I have one credit card, to work on. And we've talked about this, that's financial abuse in some capacity, or what you've probably been told is it's like, well, you're not good with money, and I don't want you to mess up things. And so you just put everything on this little credit card and you don't worry about anything else, right? So it doesn't mean that it was intentional, but it means that in the reverse, you're probably dealing with a very controlling person about the money. And anytime you're dealing with a very controlling person about the money, whether or not they have some money trauma, whether or not they have scarcity mindset, and we can talk about all of those, they are going to be watching this money like a hawk. And so you're not going to be able to put money aside for an oh shit fund, right? You're not going to be able to plan ahead for everything. But your first step isn't just going in and interviewing attorneys. A lot of times, even those initial meetings are going to cost something to even have that initial meeting. So if it's $300 here or $500 here or $500 here, you could be in $1,500 just to interview 3 lawyers. So instead, obviously, because we're in the financial realm, we would say start with your financial, but it's also strategically, the finances is what keeps people in the system longer. The not understanding, going through discovery and subpoenas, and you have a person who is very controlling about the money and they own a business, they are concerned that their business is going to be worth way more than it's actually what. Like, I've never met a business owner that didn't believe that their business was worth millions of dollars more than when we came in and valued it, unless they are getting divorced and then they believe it's worth nothing. And they're talking to lawyers to figure out how to go through the system in a way to say it is worth nothing. It is all me. It is personal goodwill. It is double dipping. And again, I'm just saying some of these concepts so that you can eventually go Google them if you need to, or look and research it more if it's applicable. But Adrian can tell you, like at the beginning, when you go, now you've decided you're going to hire that shark. They're going to literally give you a form that you're going to fill out and document lists that you need to collect and all of this stuff so that they can go and fill out your financial affidavit. So the first $5,000 that you pay potentially to a lawyer. Now, not all of them are as expensive, so maybe you will only go through half of the retainer, but a majority of the retainer is pulling together this information and putting it in the financial forms. They're legal people they don't always have an Adrian at doing the work. So they're legal people putting in numbers, and you're like, well, does it matter if the number's specific? And they're like, just put something in there. Okay, that's not gonna be beneficial because, talk to us, Adrian, about the fact that like the financial disclosure is a filing in the court that you are saying is accurate and up to date. And quite frankly, if you did some of this work going into that first meeting with an attorney, you would set the pace that the attorney is now like, oh, they got their stuff together. They understand the process. I'm not going to run this process for them. I'm going to work with them because they're not coming in. If you come in highly dysregulated and like, I don't know anything, and you got to do everything for me, the clock is going to tick, and it's going to tick hard. And that first $5,000 retainer will be gone, and you will just have filed your financial disclosure. So tell us more about what you're thinking, Adrian, because I'm always a little bit harsher about all of this stuff.
So I'm going to take it into two categories. We have our people out there who, as you were talking about, Melissa, they have been removed from all financial decisions and they don't know anything. Now, there are definitely people out there who cannot access information, are removed from accounts, and simply have nowhere to start from. That is somebody who's going to hire an attorney and file what I would have filed as a preliminary financial statement, knowing that we're going to come back and have to update this once we have information. Most people know some of what goes on to it. You know the property of your house. You know the address of your house. You know that you have real estate. Maybe you know the lender. Do you know you have the vehicles that you use? You know the bank account that your debit card is tied to. So you're going to get some information, but you might have nothing about your retirement or your spouse's retirement. You probably know the name of the business that you could put down and say you don't know the value of it. Do you have debts? So there's pieces that you can pull in, but you probably aren't going to have everything. You're going to say preliminary. You're going to say, I am unaware of any retirement plan. I'm unaware of anything else. The partner, your spouse may have more information than you do. So there are legitimate times when you really, truly cannot put much together.
That trips people up because they're like, well, I don't know what they have, but you don't have to know, right?
Right. And that's what discovery, and that's where, so this is going to be the conflict in divorce where you're going to have to pay a lawyer to do these things because you lack access. So when you lack access, starting a divorce filing, you're not going to get very far. Now, you can have already put together what we're going to talk about for people who have the information. You're going to put that all together, but that's all you got. You're going to have to get a lawyer involved. You're going to have to you're going to have to force them to file a response. You're going to likely have to issue subpoenas to get records from various record holders. So when you don't have information, that's kind of generally going to put you down a certain path. Now, pulling together everything that you can applies to all of us. Any information you go into for a lawyer, because they're going to ask you, well, what kind of car do you drive? What kind of car do they drive? Are there any UTVs, boats, anything like that? You're going to answer all those questions to a lawyer, and they're just going to fill that out. So you can still start the prep. You just are going to have to, you're going to end before the ideal time, but you're still going to hand off to your lawyer a list of all of your assets, expenses, debts, and income. So sorry, income and expenses is in one place. Assets and liabilities are in another, assets and debts. But you're still going to give the lawyer everything that you know, and they're just going to file it as a preliminary financial statement, and you're going to know that it's going to be a bit expensive. On the other hand, if you can pull as much as you can together and walk into a lawyer's office, you're going to have an initial consultation talking about what do you want. You're going to have an initial consultation where we identify the key issues. You're going to have an initial consultation where the lawyer can see the scope of the case. They can give you a better idea of whether it's going to be complicated, whether it's likely to settle. Now, personalities come into that, both lawyers and clients. There are 4 personalities in a represented case, and any one of those personalities being unreasonable is going to cost you money. That's your spouse, that's their attorney, that could be your attorney or you. So coming in and recognizing that not everything is within your control. All you can control is who you hire as an attorney and how you behave. For collecting data, collecting your property statement and income and expense statement, these are the basis on which divorces occur. The divorce has to allocate and divide all property owned by the parties. That can include your separate property, things that are excluded in a prenup, things that are acquired prior to the marriage, gifts and inheritances and things like that. It's also going to include all of your marital property. That's what you got to dispose of in a equitable, potentially even, different states say different things, but you're going to divide the property. When it comes to the income and expense side, if you do not have children, you're not worrying about child support there. So you may have to worry about your kids' expenses. If you have children, you're going to have to know your children's expenses because that is the basis of child support. It's both the income and the expenses for those kids that the court's going to look at and say, who has to pay? How much do you have to pay? Looking at the income of both parties, but also looking at your kids' expenses. Some of those things, like if your kid plays hockey, it is a real expensive sport. You're likely going to end up in an agreement about who is paying for the cost of hockey. That isn't necessarily child support. That can be something else. Medical care, things like that are also going to be delineated in that way. But we look at our income and we look at our expenses to say, how much money does this party have to spend on their children and themselves? That's where you get into spousal support, is whether there is not enough income for someone to support themselves, or there's an inequitable amount of income between the potential households, especially when you talk about kids. And that's where those things like the house, the school district, the consistency all come into play. And that's going to look different for every family because some people have really low mortgages, and keeping the house and keeping that mortgage is really important right now. Some people, it's, we're definitely going to have to both rent. Some people, it's, we want to make sure our kids in the best school districts. So we're actually going to move school districts because we have this opportunity for somebody to live in an apartment in a better district. And so there's a lot that goes into just figuring out your income. It is important to figure out your income. That is going to be put more time into that. Expenses, if you don't have children and you don't expect to deal with spousal support because you and your spouse make about the same amount of income, your expenses become much less important. That's where I had a couple of friends getting divorced this year. In Missouri, and I'm speaking only from my personal experiences, round numbers are not going to throw off a judge if you're not looking for support. You can say your mortgage rate is whatever the exact dollar amount is, but you estimate that you have utilities of this much every month because they fluctuate. If you have a high conflict divorce, we are going to, as an attorney, I was going to go through, my paralegal was actually going to do this, go through all of your statements for an entire year, all of your credit card statements, all of your bank statements, all of that. And I'm going to figure out exactly what your expenses truly are. It's very time consuming, obviously, but in high conflict, and messy, large asset divorces, that was pretty normal for us. So I would say in my practice, 80% of the time we were doing that level of detailed analysis of income and expenses. Again, I worked in a very high conflict area. And I would advise, like, it's never a bad idea to go through 12 months of your expenses and get that together. You will also really have a handle on budgeting for yourself if you were the spouse who did not handle those things. It is an excellent exercise for everyone to do. It can be really hard at the beginning of a divorce, especially with an attorney on board, is like, you got to do this, you got to do this. So getting prepared mentally to go into it and doing as much as you can before you get in with an attorney will also help you know set your expectations, set your issues. You're going to go in and say, I don't have enough income for my expenses.
Yeah. Emily, what were you going to say?
Sorry, that was a long answer.
It was a great answer, though. I mean, it gave a lot of information, and it also sparked a lot of questions.
Yeah,
So,
and before we go in the questions, though, I think that if we just kind of pull it together a little bit, that, you know, somebody said that they're getting divorced in Missouri. Well, that's our specialty. But, you know, in Missouri, you have a statement of property and a statement of income and expense. So again, in most states, they're going to be called differently, but they are the same things. You're going to talk about what you have, debt and property, and then what is your income and expenses. So that's why the tax return is important. The bank statements are important. If you never had access to a joint account, first of all, if a joint account exists, even if you didn't have access, if your name is on that account, you can go to that bank and say, hey, I want the last 12 months of statements in a paper form on a jump drive. Maybe they can print it out if you really want the paper form. And can you download all of the transactions for usually 18 months onto this jump drive? So like, let the banker do some of this work for you. They will love it. They will enjoy like getting to know you. Bankers are amazing in that respect. They're like totally customer service people. But, you know, get as much information. And then you can just be like, you know, do we have any other accounts here? You know, are there business accounts? Like, again, sometimes they're going to give you too much that they shouldn't, but that's okay. And then your CPA as well. If a CPA did your tax return, you're their client. You can go back in. And again, I would encourage you go personally to their office. Like right now, they're not doing much. They're getting all ready for 1099s and filings, but they haven't ramped up. They're definitely at their office. Go and get the actual tax returns and the work papers, because that's going to have 1099s and W-2s and K-1s. All of those are important. But another piece is the paycheck stub. And so at the end of the year, you get this paycheck stub. And for kids, a lot of times the primary wage earner or the person that has the W-2 wage is going to have stock options and bonuses, and they're going to pay the insurance. So you then have that number, which is an important piece of the puzzle too. So all of these things could be beneficial, but attorneys might tell you, oh, just give me an idea of your income and expenses. Like, what do you think you pay? That I would say err on the side of getting a more detailed analysis. We did have somebody that said, well, what if you don't, like you had to leave very quickly, a financial kind of abuse kind of situation and an actual abuse situation. But you had to flee the house for safety. So current expenses are not the marital standard of living. Like what happens if you leave the house and now, you're either living with somebody else or you had to go out? Like, are we looking at our past expenses? Are we looking at our future expenses? That's a hard question.
that is.
Yeah, and the lawyer answer, it depends.
Right.
So it's going to be varied, especially for somebody who is in an abusive situation, is just getting out and going somewhere safe. You're still going to be looking for a place that you can reside. So the court's going to probably look for reasonable expenses. That theoretically may be in the house that you were residing in. There's a lot at play about separate property, who owned the house, who's going to claim it, all of the being able to afford the house and all of those things. And so the court can look at it multiple ways. If there is sufficient income that the court says, yeah, you're both going to live in houses, there's plenty of income to support two houses, you're going to probably want to utilize your old house number. If you are likely to end up in an apartment situation or something that isn't, that is a rental and not owned, you're probably going to want to set those standards sooner than later, because likely the court's going to look at it and go, okay, you're managing, you're trying to reduce your expenses, you have made an election or been forced to vacate your home, and this is the cost for you now. Now, if you're in a studio apartment because that's the only thing available and you have 2 kids, we know that that's not the real rent that you're going to incur, because you do need to get, bedrooms and things like that. So again, it's going to depend on the circumstance. I would look, if you are in a situation where you don't think you'll go back to your house or a house, I would look in a more perspective way of what is my housing situation going to look like, and then you're looking apples to apples when you analyze income with the court.
Well, and I know a little bit more about this situation, so I'm going to add a layer of complexity, because I think people have this happening a lot. They may, like sometimes people don't have a tremendous amount of retirement or savings or, money set aside, but they have a lot of money in their property. And so if you have what if you have a house that is $1 million and it's paid off? What if you have a rental property that's $1 million and it's paid off, and there's not enough money that we can just get, and they don't want to sell it. They don't want to get rid of anything. You're in a situation and they've cut you off financially. So you literally have to just make do and live with family or something until you can get off your feet. What is the court going to look at? When is it going to force the sale of the assets? Is it going to allow them to pay you over the next 20 years? What have you seen, or what do you think?
So every court's going to have a different standard for what?
It still depends.
Yeah, of course. Every court's going to have a different standard for how they treat assets and forced sales. Generally, the court is going to award dollars with not typically a term. They're going to say, this is the division of assets. They're dividing the assets and the debts. They're not saying you pay it out over this amount of time. We do have, in Missouri at least, I think most other states, you can have a term of maintenance that you agree to. The court will not order a term of maintenance in Missouri, but it will allow people to settle for, you're going to pay maintenance for 10 years of this amount every month or whatever amount of time. That can then fold into the affordability and things of your household. But the court generally isn't going to force a sale unless it is a pendente lite order during the pendency of the case, because the family cannot afford their expenses and have agreed to make a sale of property in order to continue litigating or to pay. For the most part, the court is going to award property to one party or the other. If there's a request for sale in the divorce and one person says, I want to keep it, and one person says, I want to sell it, and the court's going to award it to the person who wants to keep it and say, well, you got to pay them out. However you're going to pay them out, you're going to take out a home equity line of credit. You're going to refinance. You're going to get this cash out. So yes, it's going to depend, and every court's going to be different on how they look at whether something should or could be sold during the divorce. It's happened a fair amount that I've seen real estate in particular sold, or as soon as the tenant is out of the house, the spouse who left the house is going to move into the rental property. Things like that will happen as well.
Well, and Emily, maybe also kind of talk about it, because, in cases like this, if we have a rental property and we have a primary house that are the same, right? The problem is that the primary house might need updates, or there's things, because we have a lot of cases where they're just running the property into the ground, right? They're not keeping it up. They're not putting the money in. It's not going to be at that appraisal amount, and what if the judge is like, okay, you get the house and you get the rental property, and I always say, I don't care if you want to keep it, if you get allocated it, then sell it. But what's the impact? Or in $1 million house, Another thing that people are concerned about is that, am I going to pay capital gains tax on it?
Yeah.
Right? So all of these, maybe Emily talk a little bit about that, and then Adrian can talk about the capital gains issue, because there's a bunch of, but these are regular things that I think, even if your house isn't $1 million, if it's over 500,000, and a lot of these people live in you could have a small house in California and it's still going to be $1 million, right? So things like that. Emily, what are you seeing?
So there are issues when you move into a rental too. So we have an issue of basis then. And so there's like penalties and things like that, and numbers that they're not just equal, right? So there can be repercussions for just, oh well, it makes sense. So everybody thinks that mortgages are common sense. Oh, I can afford that. I can do that. There is not one thing that makes common sense in a mortgage. Like, the guidelines are very specific. They dictate every single little thing. And so when we're talking about, like you guys were talking about, oh, a sale, it just seems like that's the only option, when in fact there's 15 other options. You can, do a refinance, you can cash out, you can do a HELOC, you can do a lot of things with your, rental income and things like that. And also, if you have like an income producing property like a rental, is that potentially worth more because you are getting income from it? Do you have to move into it? You don't. You can move somewhere else and keep that rental property. But then, it's funny because you also have trouble getting mortgages if you live in a rental and then you're buying properties that are rentals and you don't have your own primary residence. Underwriters look at that too. It becomes a huge issue. So I find it hard to answer some of those questions because I feel like the lawyer response. It depends. It depends every single time. It depends, because then the guideline changes every time you tell me something.
It's because it's not only just income, it's, risk. A lot of times people are like, well, I don't know if I want the risk of having a rental property. I don't know if I have the money when something goes wrong. And again, I think what Emily's saying is the property is an asset. So you can get a HELOC or a home equity line of credit that you could pull from if you needed it. But at the end of the day, you can't just be like, okay, well, they're going to keep everything and pay me out. That's a risky endeavor too, because they're going to have to pay you out over time. Where are they going to get the money? We can be asset rich, right? And we have these $1 million properties, and we can be very cash poor in that we're not having, it's still very illiquid in some capacity. So I think you're weighing a lot of the issues and you're figuring out, but if you are in a new situation, you have to figure out what is the expenses that are going to be going forward. If you're couch surfing or you're with family, I have advised people, go out and look at what a 3-bedroom looks like, right? Get them to give you the information on the rent for the 3-bedroom, the assumed utilities of the 3-bedroom. What are you, this is included, this is not included. And that is at least a basis for, putting something in, even if you haven't rented it. But also, you might want to go to somebody like Emily and say, can I get this, what would entail in this commercial property? And then Adrian, okay, let's say we sell it. Let's say I get the $1 million house. Am I going to be now paying capital gains tax on this house? And how does that work with basis and such?
Okay, so we will do a quick income tax lesson. Yeah. Yes. One of the big incentives you incentivize behavior through your tax laws, just as the baseline. The U.S. tax law incentivizes homeownership. Homeownership has a bunch of beneficial things in the tax code. So just to set that baseline. in the tax code, if you own real estate and you have lived in that real estate for 2 of the past 5 years, and you're a single person and you sell that real estate, if the real estate has appreciated, meaning you bought it for $100,000 and now you're trying to sell it for $400,000, the first $250,000 of that appreciation comes tax-free as a single person. When you're married, that's $500,000. So if you are in a state like California, where appreciation, California, some of Florida, New York, where appreciation can happen very, very quickly on real estate, you may have seen $500,000 in appreciation on your home or on property that you own, which may make sense for you to avoid capital gains taxes to sell it before you get divorced. Because then you get to exclude $500,000 of capital gains from the sale of the real estate. So it's very important to involve someone like Emily, someone who, or your CPA, to understand these tax implications of real estate, because they are complicated, fairly simple metrics, but there's a lot of things like, what's the basis in the house? Do you have solar panels on your house? Do you have an EV charging? Do you have, brand new windows and doors that are going to increase the value of your house? Those are also going to increase your basis in your house, because they're capital improvements that increase the longevity and benefit of your house and beneficial use of your house. So there's a lot of nuance that comes into how capital gains work, but you can remember it's round numbers. $250,000 of capital gains are ignored by the IRS on an individual sale, and $500,000 for a married couple selling real estate. Doesn't matter if you are not on the title or on the title or deed for the property or mortgage. If it's sold, that's in your taxes. It's in your jointly filed taxes. There are some rules, and I can't remember them, about how you handle that on separately filed taxes. You may have to file jointly in order to get that benefit. Again, this isn't my practice area. I know the laws, but I would have to go get that nuance for how you have to file the taxes.
A lot of times, even when you're hiring professionals in the divorce situation, understand what role that professional is. If somebody's coming in to give you information about your divorce, they are not the one that's going to actually put it on a tax return. Like, you need to go back to your CPA or find a CPA, talk to them about, because right now, if you got divorced this year, right, and you get the house and you're going to sell the house, you're filing separate, right? Like, you're not going to be married by the end of the year. You're going to file separate, maybe head of household, single, whatever. You need to have that person. And this is really important. Like, even a financial advisor, when you're talking to somebody for your divorce, it could be very different than your financial advisor that's going to get you the most money and help you retire into the future. That person may not be the right person to talk about what to do in the divorce. Like, divorce is very, very nuanced. Your CPA may not be the right person to talk about what to do in your divorce. They are the after effects. Like, you almost want to be like, okay, we're talking about this divorce stuff. Now we go to these other outside professionals and say, how is it going to impact? Right. And those are separate discussions. The more you delineate them, because, like, if the three of us got involved with you during the divorce, we're out. Once you get divorced, we are no longer in the picture. And now your CPA or your financial. So, like, getting them coordinated so that you know what you're negotiating for, and that what you're negotiating for, what impact it has on you. If you think your divorce people, your CDFA, is going to care how it actually impacts you in the future, they do not. And I have seen a lot of CDFAs, no shade to the profession, but these are typically people that were financial planners or CPAs, and they get this CDFA because they're like, oh, I'm going to go do divorce. But they're not doing a lot of high net worth, high conflict divorces, and they're not going to be involved afterwards when you now have a huge tax implication. They're going to be like, oh, I mean, you can look in their engagement letters or in their caveats that they're going to be like, I'm just giving you advice to settle your case. I don't know the implications of what it could actually happen because I don't know everything about your situation. So that's where pulling your financial consultants on the outside, maybe together, so that you're having this conversation together, like you can always then convey it to the lawyer. The lawyer is really the lead, like the lawyer doesn't also care what happens at the end. You say you want the house, they're like, well, let me go get you the house. And they're not going to know if there's going to be a financial implication later. So again, sometimes this does get costly, but a lot of times your CPA and your financial planner are not going to charge you for these meetings. Your financial planner, if they're really good, are going to make money when they invest your money, when they do different things, find somebody. And again, I even have financial planners that I've been hooking up with people that are in other states. Like work with somebody, and like a lot of my people, like they put in tremendous amount of time to help you navigate what is going to happen. And you're asking me what your tax consequences are. I'm going to tell you, I don't know. I'm going to tell you this is the best deal for you, but you need to then understand what the implications are from a tax position, because you will be on the hook for that. Like you're not going to have that, and find somebody that maybe knows how to work around some of these things and be creative. But at the end of the day, they're going to file your tax return. They're going to be the end all be all about what happens in this. And if you don't have a CPA, they're not that expensive to be doing personal, like in the wide scheme of things, they're probably going to be the cheaper end of, you're paying $5,000 retainers. You might pay $1,000 for a good CPA to do a lot of things. Like sometimes it's only a couple $100s for a simple return. You're not going to have a simple return. You need to have somebody that has a little bit more depth of knowledge, and so that they know some of the loopholes to maybe play around with, right? Or we have a couple people that are realtors, and they're like, well, I know the impact of selling this house, right? But you don't know the impact of the financial consequences. So talk to the right person about the right issue so that they can follow it forward.
Please, 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 for the love of whatever that is good, make sure that when you are talking to somebody, that you're not trying to get one person to solve all the issues. So when you come to me about a house, right? And there's potential capital gains or basis, or, oh, my husband moved into the rental and, so he's been living there for a year and this and that. When you start telling me all of the things, oh, we missed a payment or this thing, that, listen, there are only so many questions I can answer without other professionals. I am not going to sit there and talk about the impact of capital gains or basis or any of those things without involving a CPA. Zero chance. I am going to stay in my lane. However, I will see people online. I complain to Melissa constantly. I'm like, this CPA was talking about mortgages and da 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 da. That's not their lane. And some people don't stick to their lane and bring in the professional that's necessary. And those are the ones you kind of have to watch out for. So you want to make sure. So I might say, well, so there's a person, I don't know if they're on here today, but there's a person who, she is the only person on the mortgages and the title to 2 homes. In the mortgage world, she can do whatever she wants. She can sell it, she can keep it, she can do whatever. But in the legal realm, it's marital, possibly, and you're going to have issues. It's going to have to be separated somehow. That's not for me to talk about. That's for me to refer back to the legal advisor to do whatever it is. If it's your attorney, if it's the mediator that's handling the whatever, that is for that person to figure out. But in the mortgage world, it's yours. It has, we don't need anybody's permission to do anything. You can do whatever you want with those mortgages.
And this brings up a really important thing, because one of the things that we've had a really hard time with in the past couple weeks is attorneys not wanting or allowing financial people to get involved, right? So anytime you have any professional, I would say across the board in divorce, that wants to gatekeep what they're doing, even if it spans into accounting, even if it spans into financial, it's a red flag, right? So you have to trust your instincts. If you're like, you know what, I think I need to get some advice from somebody else, the answer is yes, you do. And you don't always have to ask permission from your attorney. You can get a consultant, you can talk to other people. Now, in one situation, I don't think they're on here. We have had attorneys that have fired them based on doing things that they, like, you're leaving your attorney out. So if you hired this attorney to do everything, remember at the beginning, we said you hired them because you didn't know anything. Oh my gosh. Now you got more details. Now you did your research. Now you're educated about the process. You're changing the dynamic with the attorney. You need to go back into the attorney and be like, hey, we're a team now. And that's not always going to work well. You hired a bulldog, you hired a shark, and they're like, who are you? I know how to do my job. Who are you telling me? There's a lot of egos in the legal area. Even the most nicest attorneys have a big ego. So understand that you still need to protect yourself. And if somebody is really pressuring you to do things that just don't make sense at a gut level, you have to trust your gut. Like, people change attorneys because they're not advocating for them. They are out of their league. They are saying, oh, you don't need a financial person because we can tell you what you're going to do with the house. That doesn't always equate. Just because they had a house in the past or they had a rental doesn't mean they understand the legalities or the financial pieces of it. So you have to start advocating for yourself, but know there could be repercussions. And so have that discussion, like today after this meeting, I am going to go on a call with an attorney, and they already have an expert witness, and they're just failing left and right. And so this client is kind of bringing me in, surprise, surprise, we got a new person in town. Well, I can work as a consultant. I can make you guys smarter for mediation. I can come in and just help you with the settlement offer or the mediation prep, and you can still keep that local expert, right? You could still keep their favorite CPA or whatever. But at the end of the day, if it doesn't make sense to you and somebody wants to gatekeep and keep you out of more knowledgeable people, ask them why. What is the worst case scenario? And again, they might be like, well, you can't afford to pay me, so you're going to go pay other people. Like, these discussions don't seem logical, but that's what happens. Like, lawyers are interesting folks, and they are very, like, they don't keep their opinions to themselves. So they're going to be frustrated with different various things because you entered the relationship different. Anytime, it's the same with your spouse. When you entered the relationship, you maybe were like, fine, take care of the finances. And then you're like, you know what? I want to know about the finances now. And they're like, no, you're changing our relationship. You're changing the deal that we had. And so you have to go back in and discuss with them, like, I'm going to bring in a consultant. I think I need a CPA. I think I need a mortgage person to understand, right? I mean, Adrian, have you ever seen people pull in? Because I have been telling people when they go to sign those mediation agreements or marital agreements that maybe they should have a second person take a look, because I see a lot of attorneys protecting their own butts in those agreements as opposed to like advocating for their client. They're sneaking in some language of like, hey, you could have done more discovery, which maybe also leads us into the discovery piece, which is a difficult area as well.
Yeah, so I have a couple of notes from a couple of things that were said already.
Yeah.
So I just want to, it's a little bit of a go back is, we're talking about playing in the dark and preparing before you go into a lawyer. Hopefully in that process, you identify the people you need. That's the benefit of taking your time before you go into a lawyer and saying, I now know I need a CPA because of this, complication. Because I think we're going to have to sell the house. I know I need a financial expert to help me figure out how to invest because I have no background and knowledge in that. So I need a mortgage specialist to help me understand what I can afford, what I can't afford, whether I can keep the house, all of these things. When you do that ahead of time and you come into the lawyer and you say, I have this person, and this person, these are the things they're doing, just so you know. When you set that as a norm from the beginning, it's obviously going to be very powerful to the attorney. It's going to be that you are prepared. It is going to be that you are limiting and setting the bounds. Now, those people are there to help the attorney as well. Finding an attorney is a process. The first attorney you interview, the bulldog, the shark, they might not be right for you because if you need more assistance, if you need a gentler hand, you need to be finding the right people to represent you. The other thing there is most attorneys have staff. They have a paralegal and they have a legal administrative assistant or whatever else we call them. Your legal administrative assistant, where I practiced, was free. If you called my administrative assistant, ask them, when do we have that meeting with the attorney? She can tell you. She will not charge you. You need a copy, you need something out of your file. She is the person to go to because she can access everything. She gives no legal advice, but she doesn't charge anything. My paralegal, for me, because I was in a mid-sized firm and had a lot of clients, my paralegal did a lot of the preparations of financial statements, and that's pretty normal. So you're probably, if you're in a firm that isn't just a single attorney without support, you're probably going to work with that paralegal. That paralegal runs at a lesser billing rate than that attorney. Meet the paralegal and the administrative assistant when you go to meet your attorney. Ideally, they may not be there. People take vacation. But like if they're around, say, can I meet the paralegal I'll be working with? That is going to help you. That is the personality you're going to probably work with as much as your attorney, unless you are a super, super complicated, very expensive case. That paralegal is going to probably know your case better because the attorney has a lot more cases moving in the court system. Paralegals are amazing. I will exalt them. They are the best thing. They keep attorneys sane and they keep everything running. So paralegals are great. Get to know them. They're wonderful. They're lower billing rate. The other thing that I want to say, and this is for all professionals, is I don't know is an answer that you can take as acceptable. A good attorney is not going to lie to you, is not going to try to make up an answer. They're going to say, I don't know, I'll have to look into it. I realized this when I said, yeah, I don't know if you have to file marital or separate when you sell a house. I don't know. I can go find the material. I know how to find the material. I don't know off the top of my head. People who are willing to say, I don't know, it's there. You should not discount their knowledge. It's simply that they recognize the limitations of their knowledge. And that's something that I definitely saw around me was people will give an answer to a judge in chambers, to a judge in an open courtroom that isn't right because they don't want to say, I don't know. Whether that's a party or whether that's an attorney, it goes both ways, but I don't know is an answer. Okay, so sorry, I had to go back to that, Melissa. Now, what was the question?
Well, I think now we kind of, and we have some people that, wish they would have kind of either hired a smaller firm or, and we have some questions. I think, well, we're going to get to the questions. I think the other thing that we see people more often than not is the discovery becomes laborious. And so, like you file your financial disclosure, they're supposed to file their financial disclosure. They don't, or they don't give you discovery and things like that. And I think that becomes really the abyss that we sit in, because can we do a full settlement offer? We need to have some of the information kind of thing. So tell us more about discovery.
So discovery is where most cases languish. It's a long process. It is everything from when you get filed for divorce up until you get settled. It's pretty much all discovery. there are steps along the way. In St. Louis County, where I worked, there was a mandatory document exchange that said that every party had to exchange certain records within their possession, things like tax returns, pay stubs, mortgage statements, credit cards, bank statements, all of those things. Not every municipality, state, court, county, whatever city is going to require those sorts of things that initiate some level of discovery. Discovery can be had through a lawyer and through subpoenas. Lawyers make discovery happen. That's why in conflicted divorces, lawyers are really important, because they're the ones who can force and get that information if you're not on an account. So while we can say, go to your bank, go to your CPA, go get the information within your purview, if it's in your spouse's name, you can't call their employer and say, hey, I need a copy of their 401k statement. You're not going to get it. If you send a subpoena without a lawyer's signature, you're not going to get it. So that's where lawyers come in discovery. And that's the bulk of the job, is to understand and gain information about the issues, the assets, the liability, the debts, and all the income and expenses. And so that's where lawyers spend the bulk of their time, is drafting interrogatories. Interrogatories are questions that you send to the other party, asking things like, do you have, I had a standard set, everything from name, address, social, children that all the children are listed. Where do you have accounts? Has there been any misconduct? The interrogatory standard list that I had was at least 30 questions with every case that I'm going to send out and ask, so that I know the basis of the issues. Then you're going to get a request for production of documents, or something titled differently for every state. And a request for production of documents is that you're going to send directly to the other party, asking them to produce the documents if they exist, all of those things. That's where I'm going to ask my client spouse for business records. I'm going to ask for old tax returns. I'm going to ask for a bevy of things to go directly to the spouse. If I don't get everything from the spouse, that's when subpoena deuces take them. I say it wrong every time, but it's SDT if you see that written out. It is a subpoena to the custodian of records. It's a request for records from the custodian. So you're going to subpoena JP Morgan. You're going to subpoena Chase. You're going to subpoena Citibank to get all of these records that your spouse hasn't turned over to you and that you don't have access to. The final discovery methodology that's generally used is a deposition. And that's where you're going to sit down with all the lawyers and all the parties and a stenographer or court reporter, and they're going to take notes. That's where you get to ask all your questions. In trial, you never ask a question that you don't know the answer to, and that's what depositions are for. It's information gathering. Depositions come near the end of the case because they are so expensive. Most cases don't need them. You can resolve things without it. But imagine you're sitting in a courtroom, or you're sitting in a meeting room with two lawyers all day long. They're prepping for it and prepping you for it for days. If they're a good lawyer, they should be prepping you also. Just make sure your lawyer preps you for depositions. They require a little bit of thought. Not a little bit. They require thought. They require you to be self-aware and know your biases and know your person. But depositions is pretty much towards the end, and you will have one more chance to issue subpoenas, and then you're going to trial. So if you get to the point of deposition, you are very close to trial. You've gone through all of it in every way to try to resolve the case without depositions and trial.
And I would say prep with a financial person, because they, I am deposed more often than trial, because again, I think if I do a good job in the deposition, they should be scared to go to trial with me, because I will perform. They're also going to look at your deposition as whether you're going to be a good witness. And so if you're not prepped for it and you show up and it's just horrible, the other side's going to think, oh, this is going to be great. You're going to be horrible on the stand. And that could be a conversation as well. We do have a bunch of questions. I'll kind of try to go through some of it. We had a person in Missouri. We had a person in Utah that submitted their information, even though their spouse has more of all the files. We had somebody really kindly say they were grateful for our increased presence on YouTube. We're going to change the game and how women move forward with highly empowered in their divorces. We had some people got like the 1099s in the mail. Like, don't discount like looking in your office in your house, like getting on the personal computer and check like trying to get into TurboTax or whatever it is. You know, you can also go down to the IRS or go online and get a transcript.
Transcripts never have as much information as the return, so we do prefer a return, but a transcript at least gives you the income, the high level stuff. But yeah, there's usually people don't think about there's files everywhere, whether they're electronic or paper, but they're usually somewhere in the house.
Somebody said they became like when they were doing their financial disclosures, they were getting really stuck because they wanted to be extremely honest and accurate, but then it kind of made them freeze in the process.
Yeah, and that's why, for example, with my friends who didn't have support issues, I told them, you know, these are estimates. You can always call it preliminary and you can always go back to it. It is really hard. It's really hard to say, like, I am worried about my income. I am worried about being able to live my life. I'm worried about being able to afford things. So I'm going to be very intentional, but that's also then can be overwhelming. My advice has been do it piecemeal, take your time, do not rush through it. It's not only are you dealing with like stress related to your continued life, you're also dealing with like anxiety about what's going on, even if you're doing this in the dark and they don't know you're doing it. There's a lot of emotions about divorce that are not necessarily good or bad. They're just emotions. People feel ways, and you're going to, because this is a stressful process, difficult process, mourning something that is lost. You may be celebrating in some ways, but there's a lot more emotions to it than good and bad.
Yeah, we also had somebody thanked you for answering the question. We kind of smushed that up whenever they were talking about like financial abuse and kind of kicked out of the house. You know, somebody mentioned, are they actually going to pay you if, you know, like even with alimony, even with like all of these things, because there's one thing with like child support, even if you get child support, if you're not actually going through the state and filing it through the state, it's still like on their own volition. And it impacts the house too, if they're not paying in a regular basis or things like that. So
yeah, a child support order, how do you get the money? Unfortunately, the answer is more court. You have to file another pleading that they have not, you basically have to start a civil case that says that you're due money and you haven't been paid. Child support has criminal non-support as an option. Yes, you can go to jail for criminal non-support. Generally, courts, in my experience, didn't like to do it because they said, hey, you're definitely not going to pay child support while you're in jail. So you think of it as an option, but realistically, the court will do it. I've seen it done, but it's not necessarily as likely as people think. They think, oh, well, you're not paying child support, you're going to go to jail. The court's somewhat logical here and says you can't pay child support if you're in jail. So we're going to figure out, you know, other methods.
They owe you on the house. Like, are they really going to sell? Like, are they going to drag their, like, you have to have other, like, there's other protective things that we put in play in the agreement to kind of elicit that they actually do that. But again, there's no police in the court system. There's nobody that's going to enforce this. So if you're saying, oh, okay, you keep all the property and then pay me out someday over time, like that is a risky endeavor. Like, let's not be confused, right?
It is, and you know, with support, right? If you're wanting to keep the house or buy a house or whatever, the guideline is so precise. If you don't get that support one time in that 6 months, or it's paid differently, you have to start over for that 6 months countdown. It's unreal. You really have to have that like kind of agreement in place, or it has to be maybe garnished or done through the state or whatever. And then also with the agreement to maybe refinance the house, whether you're paying the spouse out or not. I have one that I'm helping somebody buy a house right now, and her husband agreed 8 years ago to refinance the house out of her name. Still has not done it. Now, he didn't owe her equity, but he still hasn't done it. Luckily, there's this rule in place that says that we don't have to count that against her, that home. But at some point, the underwriter, I've had it happen one time where the underwriter was like, why hasn't this been done? It's been 8 years. This, I don't know when they're going to change their mind and they're going to say something has to happen because we're going to have to start counting this house. It hasn't been done.
Yeah.
So they, guidelines are a fickle thing. They change all the time too. So, and these are the things that you need to know, and they're on a case-by-case basis as well.
Yeah, and you're doing the refinance or a loan assumption after you're divorced, right? Yes. And so if they're not paying in a rational form, it does impact things. So
because you have to have the finalized agreement to pay out a spouse. The lender will not pay out a spouse without a finalized agreement. It won't happen.
Yeah.
So,
but also, like, even just to get, like, now you need those support payments to start coming at a regular basis, or else you can't do what you need to do, which is refinance the house. I think that that's where in any agreement you need to have that if I need to enforce this agreement, you are going to pay for my lawyer's fees. Because, like, people will be like, well, put a lien, like, you can be the first mortgage on the house. Okay, you still have to go enforce and foreclose on that house, and you're going to need money to do that. So anytime you have to enforce that agreement, ask for, like that they will have to pay any of the fees, the attorney's fees, the collection fees, the processing, whatever, as robust as you can. And then also a lot of times if there's long-term maintenance or spousal support or payments of property, we have life insurance policies that have to stay in play in case they die, right? Mm-hmm. You might have to get an additional life insurance policy. And, what does that cost? So there are ways to try to protect it. But at the end of the day, I had a former judge that told me this, and I thought it was great about a parenting plan or a mediation agreement or anything. How enforceable is the agreement, right? So you have to know, like, if your spouse is a flight risk, right? We had a client that, like, he literally did leave the country. And she was like, I think he's going to leave the country. We're like, oh, they never do. He left the country, like, before she could even serve him papers. So it delayed the whole process. And, trust your instincts on some of this stuff, because if your person is really shady, you might want to say, no, we need to sell this house, right? A force, like, then at least it goes into escrow. That money goes into escrow, and you have a little bit more even if it sits in escrow until you figure things out. If somebody's depleting assets, you might want more of that escrow. Like, you might want to get to the point where, hey, you've depleted all these other assets. I want 75% of what's in the escrow, but that's going to be a negotiated outcome that's going to take time. So at a minimum, you keep it and leave it in escrow. And we have a case right now that it's been in escrow for a year or more. And he wants that money so bad that he's willing to kind of negotiate finally a settlement when he's been highly toxic the entire time, And so now we're like, okay, well, you've done all these bad deeds. We want 60% of that escrow agreement, or we're not going to sign the papers to release it. Right. And he almost got her to sign the papers. And I was like, if you sign these papers, like, and let it out of the escrow, like, you're done. Like, you're not going to have, you're not going to be like, oh, I have a judgment against you. How are you going to collect on it? Like, if these people have evaded the IRS, if they've evaded, like, if you're divorcing a lawyer or police or former military, like, they do not care about the law or the rules. Right. And so that's where you're going to have a harder time. You're playing by the rules in the court system. They are not. Oh, that's not fair. Contempt of court. They do not care. Like, don't get gaslit by, like, these motions are going to somehow protect you. You got to get a little bit more crafty. But again, that's not the lawyer advice, and that's not the financial advice. That's just like, protecting yourself in some capacity. Okay. Assets do not equal income, and very important for the mortgage. We now have a spouse that's pro se, and I think my attorney is ready to put this bully in place, but she just wants to keep her farm and manage all these big egos on top of everything else. And then we have somebody that I kind of wish I would have hired a smaller firm. Let's see. Emily posted, I was told locally that in the basement of the courthouse, there's an attorney that volunteers their time to give legal help. You can make an appointment and go up there, filing documents, answer questions. It's not a clerk, but an actual attorney. Not sure if this is the case in your area. Adrian, do we have some people at the courthouse that can help? Have you seen that in Missouri or Illinois?
I'm not aware of that, but I wouldn't be given my experience because I was doing it.
Smaller towns may have somebody, but it's usually is a clerk or like an administrative person there. Like there's not, I mean, realistically, it's crazy because if you go in a criminal side of law, like you can get a, court appointed attorney, but in the civil side, which is divorce, like there aren't any court appointed people that to help you. So I would still go to the courthouse. It's worth it to go and ask them questions. They do have law libraries though, but
they also have all the forms. So I've seen it happen enough times at the DMV that I think that's my corollary is when you go to the DMV, you have to have all the right pieces of paper or you're going to get turned away. The same happens when you go to file. If you're filing for yourself without an attorney, you're filing pro se. You have to have all the pieces of paper ready. So going in and meeting with somebody at the courthouse to say, hey, what papers, what names of things, especially if they don't have a robust item online, a robust list online, is like going in and saying, what do I need to do to file for divorce? You might have to go somewhere, maybe you went to the wrong part of the building, but they'll at least be able to tell you what forms you need. Again, these are public servants. Be really nice to them and they will be really nice to you. Be really rude to them and they will make your life hell. As with anyone, kindness, lead with kindness. That's just in general. But like people in the courthouse, they're paid to be there. They don't necessarily care, what your issues are. They're not your therapist. They probably don't want to talk about what you are going through, but they'll at least be able to direct you to what you need information wise to file.
Yeah. I don't think they care about the outcome like you do, but and this was an attorney who told me this in my county. Okay. And and she is the one who is one of the volunteer, like she'll do some hours. And she actually gets an award every year for how many hours she gives away. But, isn't it worth going up to the courthouse just to find out what you can find out? Like it's worth going up there and getting the pieces of paper or the list of, documents or whatever it is. And we have a pro se advocate on here fairly regularly, like once a month, maybe. And she often talks about, people going pro se and then just doing it blindly, not knowing the etiquette, not knowing, that is another, hey, you say kill him with kindness in the public servant realm. Same with the court system. Learn the etiquette. Learn, what's expected in the courtroom when you go. Stick with the facts. Like I was asked to help somebody get ready to, I don't know, do something in court. And I just got on chat and I'm like, okay, here's this person's whole story that was, this long. I was like, how can she present her requests in court? And it laid it all out factually, organized, beautifully. And I gave it to her. I don't think she followed any of it, but it probably would have gotten her a little further because she did not get what she requested. But every little bit helps if you're really kind of either like even accepting the tone that maybe chat gives you to help you present in a courtroom setting or something like that. So these are just things I hear.
Somebody said they wish they would have known that tidbit about the paralegal. So that was good, Adrian, or the legal assistant. Somebody said their pro se ex was already making mistakes. They set a final hearing without notifying anyone. I happened to notice it on the court's public portal. And a lot of times you do need to stay up to date with what's happening on the portal, or, checking in. I do, and this is where this is a random piece of advice that I think is beneficial. Some people have been like, well, that works up my bill too. Well, you got to figure out if it works or not. But like having a meeting, even just a 30-minute meeting every other week with your attorney on a regular basis, I think is great. You keep all your questions together. You say, okay, I'm going to ask all my questions in this half hour. You try to make it a half an hour. If it's an hour, okay. But like, what hearings do I need? What do I need to prep? What do I need to put together some of information for these exhibits, or are we doing a PDL? Like my spouse did this. What should I do? How should I respond? They missed a payment on the mortgage. What should, like a lot of these things, you need to be a little bit proactive. But if you're sending emails to them every single day, they're going to bill you for all of those 10 minutes, 10 minutes, 10 minutes, and you're actually going to just eat up the response time. Whereas if you come every other week and you just say, because at the beginning, not a lot's happening. So these could still be the time that you're up to speed. Like, should I, because they'll wait till the last minute. And then, like we have a PDL hearing. I got to go on in a half an hour. That's the case that I'm going to be. I'm like, hey guys, how are you? Why are you not ready for your PDL hearing tomorrow? But last week they started all of a sudden getting the income analysis ready on Thursday and looking at the business for 2025, which was the financials were crap. And it's all at the last minute. So the client's like, this is crazy. Attorneys and experts work at the last minute. We have tons of cases. And then all of a sudden, oh, now we have a hearing next week. Let's get ready for it. That makes normal people who are like, like, I would like to have this done weeks in advance. Well, go in and have that be willing to pay. Yeah, Adrian.
Yeah, I mean, I think I've got a couple of notes on that concept too, Melissa, is like a couple of the things you said. I was like, that's paralegal, that's LAA, legal administrative assistant. Do I have a hearing date? All of those things. You're going to not ask your lawyer. But I agree, setting norms, get a calendar from your lawyer for especially the beginning. If you are the first party filing, nothing is going to happen until the response comes from the other party. Every court is going to say you have this many days, maybe 30, maybe 60, maybe 75, maybe 90, maybe 120. But for the most part, represented and unrepresented people can get extensions on things. So even though it's like, oh, you have 2 months to file your response, if they get represented at the last minute, they're going to say, I need another 2 months because I just hired a lawyer. And suddenly it's 4 months. And now we're 4 months into this and you have no more information than you started with, but you're still wanting to talk to your lawyer. So setting norms about when you talk to your lawyer. Now, things are going to happen in the interim. You're going to have conflict. The divorce has been filed. There's going to be conflict. You may actually need to talk to your lawyer. But setting, kind of in your mental calendar is like, my lawyer is not going to initiate contact with me until something gets filed. 9 times out of 10. You may need to initiate contact with your lawyer, but probably not the other way around. Every time you contact your lawyer, you're going to get billed for at least 6 minutes of time, which is 1/10 of an hour, because you're going to read an email, you're going to shoot that email off, you're going to do that. And that's how they bill. And they're going to go back to those emails, say, I wrote that email, I wrote that email, I wrote out that email. So you're getting billed for that. Having the conversation is definitely the way to go. Put 30 minutes on the calendar. If you know it's going to be more, give them more notice. It's those issues of custody, real estate, not doing things, not giving records. Strategy. Your attorney is there to advocate on your behalf and enforce a strategy to resolve your case. Sometimes that's maybe sometimes that's court. Most of the time that's going to be through a settlement where keeping everybody on the same page about what is reasonable and making sure that you have 4 people who are acting in a reasonable way is going to help keep your costs down overall. Sorry.
Yeah. Okay, let's see. Delay. That's what the playbook has been. By the time it gets set, 9 months have passed and it's still not complete. This is so draining. Somebody has a question. If a couple are living separately, but one person controls the finances, does the other spouse have any rights to get access to their money during the long divorce process?
You have rights too. The likelihood of that, it varies. You have rights, and if it's in joint names, getting it is obviously fairly reasonable. If the other party is the only owner of things, the only way that the court can do that is through what they call a pendente lite order, which means a order that exists during the pendency of the divorce. Now, that obviously means you're represented by an attorney. At least in my practice, judges do not love pendente lites. Attorneys do not particularly love them either. The judge does not understand why the parties cannot figure this out and come to an agreement themselves, and is taking court time to have a temporary hearing. It's expensive, it's time consuming, but obviously if you have no access to any resources, you're going to have to file a pendente or file a request for a pendente lite order in order to have some sort of access. It's not always successful. And you would probably try to come up with some sort of a settlement rather than go to court and have a hearing. It may only be access to one thing. That might be where you're talking about selling the house or converting an asset or converting something into joint names and dividing it and then saying that's what we're going to live off of during the pendency of the divorce, and anything left over may get allocated to the party that retains it.
Yeah. Let's see, temporary orders, but in my experience, he doesn't follow orders or some of them. Hence, now I have to file a motion to enforce in another. Yeah.
Yeah, there's a lot of ways that the other party can drain you, right? And that's why when you file any sort of a pleading, you're going to ask for your attorney's fees to be covered by the other party, because the reality is you wouldn't be filing the pleading if not for their behavior. So that's what you're going to put in there and say, I'm asking for legal fees, to handle this motion. Court's not usually going to award too much in the interim, but they may take consideration. Again, my experience was with one very specific court in this whole giant country with all these courts. So they may all be different. And you may have a lot of luck with a pendente lite. That's your lawyer in your area is going to be able to tell you how likely it is that you're going to get a pendente lite ordered in your municipality.
And sometimes it's called these temporary orders because that's what I think a couple of these clients are in Colorado and then Utah and some other states will call them temporary orders.
Yeah. Which is a lot nicer name than the Latin.
Yeah, PDL or pendente lite. But a lot of times also you need an income analysis. And so that's where an expert gets involved is we're summarizing what the income is for the attorneys to use in the calculation for the alimony and child support. And California uses a calculator called the ex-spouse, X as a letter and then spouse. And it was something else until April of last year. So alimony and child support are still legal constructs that look like money, but sometimes you need an expert to give you what the income analysis is, especially if it fluctuates or they have bonuses or there's other interest and dividends or they're lying on their tax returns and they have a small business and they're not reporting all their income. All of this comes into play. So it's a lot.
Just escaped me something on that thread.
So somebody said, how hard is it to enforce alimony?
It shouldn't be that difficult, but it is a motion to enforce. It is follow-up, just like with child support. It is a court order. There has been a court order to do so. I can really speak to Missouri, and I know every state really handles alimony, spousal support, maintenance different. In Missouri, the court can't order a term, meaning it can't say for 5 years, for 10 years, you pay this and then it ends. In Missouri, you have to have an open-ended spousal support order. And you can return to the court to try to get that reduced through a motion to modify. People tend to be a little more familiar with that as a child support issue, is like somebody makes less money, makes more money, you want to modify the child support. You go from a spouse making $100,000 to $500,000, the quality of life between the households will become inequitable. And so you hear a lot of motion to modify in child support, but it's a thing in spousal support too, where you can ask the court to increase or decrease spousal support, and that'll typically get started if you file a motion to modify. They'll also then ask for, or if you file a motion to enforce the spousal support, they will likely file a motion to modify to decrease their support. Then you're analyzing their income again. So this is an ongoing analysis of income with support payments, whether spousal or child support, where you're going to go back to their income. They're going to probably, if they're real smart, they're going to know how you figured out their income in the divorce, and they're going to go and try to change it from there. They're going to go into their business. They're going to go, figure out how to get money, assets into someone else's name, or things that are generating income so that they have less control. I had one very extreme version of this who owned nothing but lived a very lovely life and wouldn't pay his child support because he owned nothing.
There's nothing, the court can give you a lot of things and it's still going to be enforced. Like still need to enforce it, or they're going to come motion to modify. And like in Missouri, Illinois, usually like a 10%. Well, Illinois has a calculator. Missouri, if you've decreased it by 10% and you can kind of prove it, kind of rough average, then they're going to come in within the first 3 years and try to modify that. So I think that, again, in the agreement, say, if we have to enforce this agreement, then you're going to pay the fees for my enforcement. You're going to have to negotiate, because they're going to be like, oh my God, we don't want to do that. Well, if they don't want to do that, that's your first red flag that they're going to basically violate the enforcement of the agreement. So you might want to negotiate. That's why people want to get paid out for alimony with other property, and that feels good for both sides. Yes. Somebody said, okay, you can put something in escrow to protect it, because I know we're getting towards the end of the stuff. And then they said, Adrian, do you consult? And I think that Adrian will have a link to do consulting on valuation, mediation, and potentially on the divorceallies.com. So we will get that out. This is a person that I know who's asking the question. So we'll reach back out to you, or reach back out to me. And then we have somebody that I think we're towards the end of the questions. I think we covered everything. It just seems my ex is trying to keep me from submitting a counteroffer. Why he is determined to get back in front of the judge while he is in contempt, not paying spousal support, is a whole nother level of frustration. Hopefully that goes in my favor. I'm in Texas. Texas and the Carolinas, I just am saying, are going down as the worst. I think Washington is more like very even keeled, and Oregon, like the West Coast is a little bit more balanced. We have California is now doing a joint petition where you can do things like that. But again, even if you give a counter offer, even if you give an offer, a toxic spouse isn't necessarily going to respond, or what you're trying to elicit is where is their response. So if you give a normal offer and they're way over here, you at least have two bookends. If they don't want to respond, it's because they literally don't want to pay you anything. Like, they want to hope that the judge totally sides on their side. But in this case, because I think I know who this is a situation where they have illegal activity. Like, they have skeletons in the closet, if you will. Like, why do they? And you would think that when people have skeletons in the closet, they would not want to go to court. But those people do not care about the law, right? So
my one trial, I had one trial, and it was that person. Yeah, because people who are willing to lie about, he had a list of lies that I had a judge in chambers say, I don't even know if I can believe his name is what he says it is. He was truly, I got I did big cases. I got extreme humans. He was one of them. He did not even bat an eye at lying. He'd be caught in a lie and he'd lie more. There are those people out there. They exist. They're very real, unfortunately. And that's when I say you got 4 people in a represented case. If any one of them are unreasonable, it's going to be time consuming. Now, in that case, the judge said, obviously, she saw through his lies. That's an important component, but she awarded my client more of everything because the husband was taking actions that were definitely illegal, but also harmful to the marital property as well. So, yeah. And then Melissa, you said there was a question about putting stuff in escrow. You can put things in escrow to protect them or to allocate later in the divorce. Obviously, if something's in escrow and it requires both parties' signatures to remove it from escrow, that's a very safe place for assets to be sitting. So it's not a bad idea to throw stuff in escrow and ensure that you can come back to it later. That's pretty normal if you sell real estate, is it's going to go into an escrow fund. You might take $50,000 out and allocate it to the spouses for the pendency of the divorce, but you are probably going to keep it in escrow. It is the safest place for it. We talk about when you start thinking about divorce, can you get assets in your own name? Do you have assets in your own name? Do you have income? Do you have money that you can pay all these retainers with? All of that. And as Melissa has said, in your settlement agreement, it should say, this was in my standard template, Melissa, but it should say that motions to enforce any terms of this agreement shall be borne by the spouse who is not following the agreement. So it is, at least in my template, it was a standard language, which I will also say, if you have questions about anything, words that your attorney gives you, ask them. If they can't explain why something's in a pleading, probably not a very good attorney, or the document or the words shouldn't be there. I was a baby lawyer when I was practicing, and I didn't practice all that long, but I sat down with my clients and went through every single word of our settlement agreement to make sure that they understood what was contained in it. Because in the end, the clients are the ones enforcing this agreement, not the lawyers. Your lawyer is going to get you settled or go to trial and get you a settlement or a court order, but they are not going to go out and enforce this. They're not going to be contacting the banks on how to divide things. They're not going to do any of that. They're just going to say, here's your court order, go to the bank and do it. Honestly, I have no idea how to do those things because I've never had to, because I was the lawyer, not the client.
Any parting remarks, Emily? Because I think somebody just said, I just want to thank you all for this meeting. I'm hanging by a thread in this process, and currently you are all that thread keeping me together. So I'm so glad. I think this was a lot of information. Adrienne, I think it gives it such good, like, tactical things that they can do. And, because we're never saying that you can't, that, again, we have Tracy B that talks to you about being a pro se. It is very hard to be pro se. We have other people in this call that are pro se, and they will tell you, like, it is a second job. So if you're going to have an attorney, how do you work better with them? If you have experts, how do you lead this strategy session, and are the strategy of settlement, the strategy of everything, and be a part of it and know that everybody has a role, and how do you be more efficient? So I think that was helpful. And Emily, any parting last words about information or anything like that? We usually have a nice ending to this, but we just went right through it. So
we did. We started and finished right out the gates. Like, we went crazy. I think my parting words, I'm going to stick with the support theme that we've kind of talked about quite a bit in this conversation. Recently had an attorney reach out to me very frustrated with the kind of newbie CDFA that wanted to present support on a sliding scale of some sort. And I will tell you that if your support decreases over time, or maybe the child support, the kids age out or whatever, please understand that when you're looking to qualify for a house, we have to use the whatever that lowest number is. That is what we have to use. And so if you have a sliding scale, it, at least at first, it might not benefit you when you're qualifying. So especially if it's your only source of income. So I will say that. But Adrian, I think you do a great job kind of breaking it down into very practical, easy, digestible pieces, which doesn't get done very often in the legal realm. So thank you.
For sure.
It's a really big process. People work their entire lives to become experts on this. I did it for 4 years, and I don't know everything, even in Missouri, by a long shot. It's a lot. That's why lawyers, let's be honest, that's why they're expensive. And I had a lot of people who said it was the best money they ever spent, and I had a lot of people who were real frustrated about having to spend the money in the first place. And those are all very valid feelings, because it is a really stressful and hard process. It is the most emotional thing you will go through, but your attorney is not your therapist. Get a therapist. Have people outside of the process to anchor you through it, because it is really hard. It's very lonely, and especially if you don't have support around you, it's a very tough process, and do not discount that it is difficult.
Yeah. And as a reminder, as we do the Divorce Allies, if you're a member and you're paying $22 a month, you get to come in, you get to ask questions every single week. Next week, we're going to have Kristen, Terry, and Anna Graham will be on the program. We'll be talking about side hustles and how to kind of plan for the next phase while you're in the process, maybe how to make some money online, if you are kind of shoved out of the financial aspects. But they'll bring a little bit more coaching pieces of it. And then also, if you are a VIP member in the Divorce Allies, every month you get 1 hour with one of the allies. Maybe I'll convince Adrian to put her time in there. Ooh, that would be crazy. But you have a special link to book those times. So those are just 1 hour links. Most of our strategy sessions are 90 minutes, and all of our allies offer a 90-minute strategy session that's going to be paid on the side in addition. So you can be a low-cost member and just meet with somebody and get the strategy and come together. I think that Emily and I, and even Adrian, hope to have maybe group strategies where we're kind of bringing some of our knowledge together in this upcoming year. So we'll be talking more about that in the future. But right now, if you need to reach out to any of us, you can use hello@thedivorceallies.com, and we can get you booked in your 1 hour session. And you just have to upgrade at any time, any month. You want to cancel, you cancel. Use this as long as you need. Or as short as you need. And we're kind of like your second opinion, right? So you're coming in and just validating some issues, like we're not giving legal advice, we're not giving your full financial advice, but we're helping you along and answering your questions. So we appreciate you for staying longer, and you'll receive information going out this week. If you didn't get all of the information you need, again, Emily and I and Adrian actually shot I think it was like 2+ hours of Plan in the Dark. And so we really went methodically through what you need to do. You'll get the first section of that this week in your email. And if you have any things that you need for next week for Anna and Kristen, it'll be the full team next week. So look for that, 10 a.m. Central. We're also live streaming some of these to YouTube, not always. If I'm involved, I usually try to live stream it. Next week, it may not be live streamed because Anna and Kristen and everybody will be involved. So anyway, we're doing as much as we can. Follow us on TikTok and Instagram. We're putting out 10-minute videos that kind of give you more details about strategy, negotiation. But reach out to us if you have any questions. post online and we try to answer them. So we appreciate you. We'll see you soon. And just do something every day that moves it forward, and it will be enough, and it will be okay. And this is a long process. It's overwhelming for everyone. But you got this, and we'll see you next week.